The defense attorney told me privately that we had a very good case, but he couldn't get the doctor to agree to consent to begin negotiations. Can the insurance company override the doctor's refusal to begin to negotiate? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. There are some instances where a doctor will have the ability to control whether or not his attorney enters into settlement negotiations. You see, there are some medical malpractice insurance policies that will allow the doctor the ability to control whether or not the insurance company begins to negotiate. That's known as a consent to settle provision. If the doctor feels he did nothing wrong and does not want to settle, if he's got an old policy, in all likelihood he has the right to tell the insurance company and his attorney, I am not settling this case. I don't care whether you think it's a good case. I don't care whether you think it should be settled. I am not settling this case. We're going to try this case. Can the insurance company override that scenario? In all likelihood, the answer is no. They're not going to be able to override the doctor's refusal to begin to negotiate. Because if he has that provision in his insurance contract, now it's a contract between the doctor and his insurance company, and they've got to honor that. But many of the newer policies don't have that restriction in there. You want to know why not? It's because the insurance companies got tired of having the doctor dictate whether or not a case could be settled at the time or prior to trial. And if the insurance company felt that it was financially feasible and better from a financial business standpoint to resolve the case prior to trial, then they should go ahead and do that. And they didn't want the doctor involved in that decision-making process. So now, many of these insurance policies for the doctor for professional liability no longer give the doctor that control. I am aware that there are some policies that tell the doctor, listen, if you want that control, you have to pay a lot more in your insurance premiums. And some doctors do, in fact, go ahead and pay that. But for most of them, they will acknowledge and accept the fact that they don't need that control. So to answer the original question, will the insurance company be able to override the doctor's refusal to begin negotiations if he's got that clause in his insurance policy? The answer most likely is no, they won't. And that means that the case is going to go to trial and a jury is going to reach a verdict. So why do I share this great information with you? I share it with you because it's a beautiful evening here in Great Neck, and I wanted to get out this great information to share with you something that most people don't talk about. And I wanted to teach you how these things work in medical malpractice cases here in New York. And I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter did in fact happen here in New York and you're thinking about bringing a lawsuit, but you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.